NACDL is the association of the nation's criminal defense bar.
One of the things that I want to talk about a bit here is how we can use some motions to sort of set up, hopefully, what will be a successful voir dire, right? And to talk through that process a little bit about how it happens. I'm going to try not to spend as much time talking about what are the actual questions you're going to ask, although there's going to be some of that here too. But the idea is, how do you sort of lay that framework and that foundation for it, right? I think we're all here because we want to try to emulate, right, our heroes, the people who we saw who did this in amazing kinds of way. But even a great trial lawyer like Clarence Darrow understood that if sometimes once you've made it already past that jury being sworn in, a case has been decided, right, and they know it's there. Now, it might have helped for Clarence Darrow that he was known to influence the jurors before they ever got there by paying them a little money. But, we'll assume we're not going to take that. We're going to take a different strategy. How about that? With that here. So when I think about thinking strategically, I think, kind of about chess, right? And how we're gonna do that. Now, I'll tell you right up front, I'm not a good chess player, right? I understand the basics of it, but I don't think about it. I just can't perceive it that way. But when we're in trial and we're doing those things, it's a similar kind of strategic thing. And that is a place where I think I'm much better at, is thinking through strategically how we're going to try to get a successful result at the end of those things. And because often when you're playing chess, it's not just about that move you're making right then, right? That move is the one that you're trying to set up a successful move that might be several more steps down the line. And that's really what I want us to be thinking about when we're thinking about our motion strategy, because we are almost always starting at a bit of a disadvantage when we get to trial, right? That we are up against the government that has, frankly, more pieces on the board than we do, and they have more powerful pieces on the board than we do that way. But if we use our motions practice sort of well in the beginning, right, we can try to take away some of those pieces that they have. And also we can try to rearrange the positions on the board, right? So that when we start, right, we're in a more advantageous position for the strategy that we need to try to be successful as we go along through that. Now, I know y'all saw big things happen here in Vegas last week and over the weekend. My understanding is that I'm contractually obligated to include Taylor Swift in everything that happens, because she's got to be in everything in the world right now that's here. But, and I assume she's here somewhere. I assume she stuck around to come see this presentation. But she knows too, right? That we can talk about rules, we can talk about how they work, but things change as to how they are from one place or another, right? And while the rules of chess may have stayed the same, we know the rules of our trial don't always stay that way. Our motions practice is how we can help to reinvent those rules a little bit, right? And if you're not the one trying to affect those rules and to change them in a positive way for your client, somebody else is, right? So you need to be doing that. Now, of course, every trial is different, right? Just like every chess game is different that way. There's going to be unique things out of your case, your experience with your particular trial that you're going to need to modify and do. I can't tell you. There's so many people from all around the country, and I saw some folks from Canada here, right, internationally that way, that everything's going to be a bit different and unique. So I can't tell you, here's the thing that's going to work for yours or not, but my hope is I can inspire you to think about things a little bit differently. I've always been kind of the impression, if I can just get one thing out of a conference, it's paid for itself that way. I already got about 10 things from Miss Childress's talk, so y'all don't have to get anything from mine, and it'll be good. So, but just know that you can take skills here, though. One of the things I like a lot about voir dire is you learn certain strategies for this. It really will carry over in different trials, right? Every case and every trial might be unique, but some of those voir dire strategies stay the same, and you can really put them to good use, right? The one thing I love about motions practice as well is it finally flips the narrative where we get to be on offense a little more, and we're not just reactive, right? When I was involved in capital cases, we loved filing motions, right? Because one of the things I love about filing motions is I'm happy to litigate anything other than whether or not my client killed somebody, right? So if I can get that opportunity to get in front of you and argue about, whether or not I'm going to be able to, cross-examine this police officer about their prior history of violence, right? And, or their prior disciplinary record, right? If I could do motions in limine about that, that's what I want to do, right? Let me change that narrative back around and put everyone on the defensive, right? Instead of being just me that way, right? It's also how we change the rules of the game, right? When I'm thinking about my motions and what I want to do, I kind of try to imagine for myself, what is the perfect world of my trial? Right? What's that going to look like? Right? And then I want to file a motion to make it that, because it should be that, right? It should be a fair system. It should be something that works better. And maybe the rules don't allow it right now, but why not, right? And I'm going to file a motion that says, Judge, I think this is how the system should work, right? I think it's how it should be and how it should go. And I'm going to make them defend the wrong system because I know I'm right about it. And I may not win the first time, but I'm going to get there eventually. If we're right about it, we're going to change the narrative for how that goes because they have a hard time defending themselves about it otherwise that way. So the other thing to know when you file motions, and you file a bunch of them, is you don't have to only file motions that you think you're going to win, right? I file a lot of motions, and I'm not afraid to file them because I'm going to lose them. I don't let that stop me. Right? If I have a good foundation, a good basis for those motions, if I think this is how our system should work, the fact the law doesn't agree with me yet, that's not going to stop me from going and being reasonable in court about it, right? Because I'm going to speak truth to power. That is a part of what we do as criminal defense lawyers and what we're trying to do, right? Now, but if I'm going to lose, right, sometimes you want to lose in the best way that you can, right? And so just know, just because you want to win your trial doesn't mean you have to win all your motions, right? I, in fact, will file motions sometimes that I want to lose, right? I prefer to lose certain motions that way because it's the only way that I'm going to set up appellate error in my case, right? If I win everything, I'm going to have a harder time if I'm unsuccessful at trial on these things. And I'm going to tell you, so Ms. Childers is fantastic. I know you guys are great lawyers, and maybe y'all are the kind who all your clients are innocent, right? My cases have not been that easy for me all the time. I've had some good fortune successes, but sometimes I got to make something happen, right? I got to get in there and I got to force error in that case because I know it may not go well at trial. And I got to find a way, right, to sort of make things happen that wouldn't have happened other way through it, right? So I'm going to work on that motions practice to see how I can do that, to set up that appellate error as well, right? And again, because I'm handling these sort of very serious cases, I'm often not in a lot of different jurisdictions. Right? I'm not going to, 30 different courtrooms in a day, or I'm not in one courtroom, right, a bunch. Sometimes I'm bouncing around different places. And so when I have my motions practice as well, it helps me to start having the conversation with the judge about how I think this trial should be, about how it should work, right? And they start to then get a sense of me. They may have never seen me in their courtroom before. And I start to get a sense of them, right? And we start, again, moving these pieces around the board with me trying to educate the court about how I'm going to do this, with me starting to influence them for how things are going to go. Now, I'll tell you too, and another thing I've found as a benefit of motions practice generally, right, is I love winning them. It's great. I want to win. I get good success that way. Losing works too sometimes because if I set up that appellate error, maybe my prosecutor's worried about the appellate error, right? Maybe they have more reason to work my case out. Maybe my client's expectations get a little more realistic when they see it's not going to go their way and we work some things out. Maybe I win something and it goes well. But I'm always using this as part of a larger strategy. That's what we're doing. We're thinking strategically about these things and how they go, right? And moving those pieces on the board. So the first thing you need to do in your case, and again, I can't talk about it specifically, is you need to figure out what are going to be your problems in voir dire. What are you worried about? What are the questions that you're going to want to ask that you think your judge is not going to let you ask? What are going to be those main themes of that trial? If it's a domestic violence kind of situation, are you going to be able to ask about this stuff? If you're having a case that is, sexual assault, are you concerned about people who might come in with biases for the Me Too movement? Or if it's a police case where it's, a police charged with assault on a police officer, for me, it might be killing a police officer. Am I worried about those things? Well, I'm going to try to find ways then that I can think of some motions that are going to start addressing those issues. And it might not even be about voir dire, right? It might be a motion in limine on what someone can say or what terms they can use, but it's going to start the conversation that I can then use later on to lay that foundation for it. So the key here first is preparation, right? If you're like me, you're so busy getting ready for trial sometimes, right? You're trying to figure out your witnesses, you're getting your discovery straight, you're trying to put your exhibits together. Sometimes the last thing we think about is jury selection, right? And what we're going to do with it. And we end up scrambling, maybe going through the lists, right, the night before to see if we recognize anybody. And we don't spend as much time actually thinking through that. But if you spend a little more time beforehand, getting ready for jury selection, it's going to go so much better and easier for you. And if you do it very well ahead of time, it's going to inform the kind of motions that you can file to help yourself be successful as you go through. So the first thing you need to make sure you're doing is get transcripts, right? Get transcripts of your prosecutors from their prior stuff. And all the other people in this room, our colleagues, are the ones who are great at that, right? I assume if you're in a local ACTL association, you probably got a listserv, right? We're sending out requests. Hey, and we got transcripts from this prosecutor so I can see, because you know what? They're not doing a lot of preparation ahead of time either. And they are sticking to the same scripts every time, and you're going to see what they can do. But also get transcripts from your judge, right? From their trials that they've had. So you can see what are they doing, because they have the same kind of scripts, right? That's how you're then going to start being able to disrupt them from how they're used to doing this, right? If you find that you've got a prosecutor who's always using terms like, victims, right, through this and is making assumptions in their biased language about this, you can then start to file motions to prevent them from using that kind of language during voir dire when nothing's been proven yet. Your client hadn't been found guilty of anything yet. That way, disrupt the process and make it less comfortable for them, make it less possible for the judge to process you through the system. Look, our justice system wants to work efficiently in convicting our clients, right? That's what it's set up to do. Our job is to make it less efficient at doing that. And that means we got to get into the middle, into the nitty-gritty, and we got to say, no, we're not going to go along with this process that way. I know that might be how you've always done it, Judge, but it's not how I've always done it, and I don't think you should have to do it that way. That's not my perfect world. So I think you should do it a different way and make that judge have to justify that, right, for why they think it should be done differently. And you know what? You get to decide, Judge, now. Maybe an appellate court gets to decide later on, and we'll see what they think about it. And I'm going to lay that foundation along the ways there too, right? Now, you also need to put yourself in the position of your jurors. And I mean this sort of literally, like what are your potential jurors seeing when they're coming into the courthouse to start sometimes, when they're going through this process? Because from the very moment that your jurors are getting that jury summons, right, to appear, they're being guilt processed. Right? They come in sometimes with the assumption that someone's on trial because they're probably guilty. I know we work hard to believe in, people are innocent until proven guilty beyond a reasonable doubt. Maybe I'm a little jaded, but I think it doesn't work as well easily. And particularly in my capital murder cases, I found it, that shade of reasonable doubt got smaller and smaller and smaller before anybody heard any evidence. But what are they seeing as they're coming in? Because that's sometimes setting up this foundation for them as well. Right? Are they getting brochures, right? When they're coming to the courthouse that day, are they getting an orientation video, right? Most courts have this. Have you seen those videos? Sometimes you need to go and watch them at least once to see what's there, because you're going to be surprised that they explain some of the roles of jurors and why they're important. And oftentimes you'll hear them say something like, it's important for jurors to be able to discuss the evidence with each other to come to a decision in the case. Well, maybe I don't want them to come to a decision in the case. Right? Maybe I don't want to be reasonable with each other. Maybe I want a jury that's going to disagree and feel free to disagree. And I want to say, Judge, that isn't their job to get along with each other. Right? That's not what deliberate means to me. Deliberate doesn't mean they all have to find a way to work together. It means they have to think themselves, right? And be intelligent for themselves. And if you haven't seen that stuff, you haven't found a way, to fight against it. But if you do, now I'm going to litigate about something that's not whether or not my client killed somebody, right? I don't know if you guys are having, this victim rights stuff has become very strong around where we're at, and particularly in the cases that I'm working on, I'm seeing folks come all the time wanting to show their allegiance, right, with victims that way. I'm seeing them come wearing t-shirts that have got my clients, not my client, the alleged victim's picture on it, right, that way through all things. And the jurors are seeing that when they come in, right? So if you come into a courtroom and they've got that, it's naturally they're going to see something when that happens. These potential jurors are going to see that as well. So I'm going to file motions that say no one should be allowed to have these kind of displays in the courtroom that way. My jurors shouldn't be able to see it. They're going to see it too sometimes when they walk even in and out of the courthouse going through security that way. Are there going to be a bunch of police officers in uniform in the courtroom for this case because they're interested about it, right? So I may file a motion to prevent the police from observing this trial in uniform that way so they don't set that kind of thing up. In one of the jurisdictions I practiced at in Virginia, there was a memorial outside the courthouse doors to fallen police officers, right? Now, I don't know why they felt they had to put it there, right? This isn't the police department that way. But if you have a case that involves violence with police, right, or credibility of that, those jurors are seeing that every time they're coming in and out of the courtroom, right? That's going to have some effect on them when they're there. Because part of the problem is it seems like there's been a movement to turn our courthouses and courtrooms into memorial places, right? A place where we should have, messages that go out for what's there, okay? And so, we need to be pushing against that. We need to look through new eyes because we don't always see this stuff. And I'm gonna talk a little bit here, and Eugene brought this up some, right, about a case I had in Virginia where it was one of these kind of courtrooms that looked more like a museum than it did a courtroom, right? And we've all seen it. You walk in and the walls of the courtroom are covered with pictures of dead white guys. Right? And this is a rural jurisdiction in Virginia, right? It isn't friendly to defendants, that's for sure, right? And this is what jurisdiction, they've had this historic courthouse as 110 years old that they're still doing it, right? And now outside the courthouse, they have what I call a second place trophy, right? Which is a Confederate statue up out front, but it was, but inside the courtroom, you walk inside and you see these portraits that are there. And you know what? Okay, old dead white guy, I don't know who that dude is. That's fine, right? But the problem becomes when I have a young black man charged with a death penalty case whose life is on the line. Because this doesn't look like a courtroom that's going to look great for him. Now, our courtroom in particular definitely didn't look great because this is the back of that courtroom, right, in Virginia, in what is really, other than the judge's bench, the most prominent location in this courtroom. And what you see here is a life-size portrait of General Robert E. Lee in his Confederate uniform, right? Now, I will tell you, Robert E. Lee, although he's from Virginia, he didn't have anything to do with Louisa County, where this was, right? Anyone here ever been to Louisa County? Don't ever go. That's what I'm going to tell you, okay? It's not worth going to. There's nothing to see. And frankly, Robert E. Lee was smart enough to have never gone himself. Okay? I don't know that he ever stepped foot in this county, right? He's not a lawyer. He never fought any battles there, right? But still, there's a portrait of him in his Confederate uniform, life-size, in this courtroom, right? And in case you weren't sure what the message was they were trying to get, that little picture, the little framed thing you see below him, that's a charter for the Louisa chapter of the United Daughters of the Confederacy, right? That they hung there as well, because that should be in a courtroom. And then surrounding him, the other portraits are former Louisa citizens who had served in the Confederate Army, right? So this is their Confederate Wall Memorial in the courthouse where they want to have a death penalty case for my African-American client. It had been there for 110 years, and no one had ever raised an objection to it before. This portrait had been custom built to be in that space, had been there the whole time. And we said, you know what? This isn't what I want our jurors seeing, because I think this portrait's here for a reason, right? I think this portrait is here to send a message to the people here in the courtroom, right? It's to send a message to my client that he's less than. It's to send a message to the judge to make sure that that judge knows, right, to follow these edicts. And it's going to send a message to those jurors too, right? For what kind of place it is that we're in here and what we're doing. So we then filed a motion to have our trial in a place that did not have racist Confederate images, right? It seemed kind of obvious to us. Now you're going to see, I didn't file a motion, we'll talk about this a little more, change of venue motion. What a motion to change venue, right? It was a motion to have my trial where racist things weren't, okay? And we then did our research on this. And we went back and we looked at the history of this, and we found out in the history of this that, again, it had been there for 110 years. It was custom ordered to be in that place. There were 3 people who decided that it should be there. They were the judge at the time, the clerk of court, and the head prosecutor of the jurisdiction at that time. We looked at their research back in the history of them. We found out that that head prosecutor had been a delegate to Virginia's Constitutional Convention when they were enshrining Jim Crow laws in Virginia in the early 1900s. And he was famous for this quote, which was saying, "I'm just here to make sure black people don't have the same rights as white people," right? So those are the folks who decided this should go up. And we put on, a hearing about it. We had experts from academia to talk about how this display was very intentional, how it was part of this lost cause mythology that had happened in the early 1900s to rewrite the history of the Civil War that way. We argued about it, and we lost. My judge, who otherwise was a very good judge, but he grew up in Virginia, living there, and people will say Virginia isn't really a southern state, right? We're not really southern. We're kind of, we're basically Maryland. Well, let me tell you, we're a southern state. And the reason I know this is because the judge in his ruling said, well, I think it's okay because in Virginia, we have a state holiday for Robert E. Lee. And not just like a little holiday, like just it's National Donut Day or something, right? This is like everyone gets the day off kind of holiday, right? For Robert E. Lee, for Stonewall Jackson, right? And to prove to just what a wonderful southern state we are, we decided to put that holiday on Martin Luther King Day. Right? So Virginia's a southern state because we had Lee Jackson King Day, right? Very appropriately. And he said, well, since you've got this holiday for Robert E. Lee, he must be someone that the state thinks is worthy of honor, and so it's okay for him to have a place in this courtroom. And, I didn't agree with that rationale. But again, if I'm going to lose, I'm going to lose in the best way, right? And so, okay, that's great. This is wonderful appellate error, right? I'm going to plan on voir dire on race. Right? And this judge is going to need to be prepared now that he's going to have to let me go into race a lot here for what's going to happen, right? And I'm set up the dynamic for what I want. And I'm also building something that probably is going to lead to a change of venue motion, right? If I need to down the road, right? Now, I will tell you that subsequently, Virginia got a little more aware, a little more woke, if you will, in the next year. It might have had a little bit to do with the fact that our governor was discovered having put blackface on when he was in college. But regardless, we started to do some things. And one of the things that our government did was it actually repealed the Lee Jackson holiday in the next legislative session. Okay? And it was great because the politicians, especially the governor who wanted to get over the blackface, they wanted to point out how we can't have these racist holidays in Virginia anymore. And they made a bunch of statements about it. And the day the governor signed the bill abolishing the Lee Jackson holiday, I refiled my motion, right? And included all of their comments that they had made about how inappropriate it is to have these kind of things, honoring him, and did the best I could to put my judge in a tough position there, right? We were then about a month before trial. And so I'm pleased to say the judge finally, realized he couldn't stick with this. This is what he ended up doing next. They took it down. They did leave up the other guys, and they left the second place trophy out on the front lawn. But nobody knew who these people were, and you'd have to go look at a small plaque to see it anyway. We'll get those people eventually. And I will tell you, we went to trial in this courtroom without that portrait up a month later, right? And my client was acquitted of all the charges at that trial, right? And now, thank you. Now, I hope we helped make my client certainly feel a lot better about it. I hope things went better because of that. The other thing I'm really proud of is that wokeness in Virginia continued a little bit, right? They woke up a little more too. And as Eugene said, they actually abolished the death penalty in Virginia about 6 months later. So this actually was the final capital murder trial in Virginia history, right? And so it was great. And we were really excited about it. So all of this is being set up, again, for us litigating stuff and us fighting stuff throughout. Now, back to our program at hand. You should be aware, and I know you guys are, jurors watch everything, right? From the moment they come in, your potential jurors are paying attention. They want to look at your client. They want to see, does he or she look guilty, right? What's their mannerisms? They're reading all kinds of stuff into how they're interacting, right? How you're interacting with them and how the court's interacting with them. So you want to be thinking about how do they look, right? How do my jurors look how does my client look when they're in the courtroom this way, right? We know that they have a right to not be shackled, right? They shouldn't be in a jail uniform. They should be in a suit when they come to court. But you know what? They may have seen pretrial publicity about that. You're going to have to handle that, right? So I'm filing a motion ahead of time that says, let my client be in street clothes at all the motions hearings that we're having, right? We're going to do the trial. Why shouldn't we do it now, right? Let's set up that process for success as it goes along, because I don't want them to appear in prejudicial ways before they're there. And again, if I lose them, I'm still setting up issues for later on, right? I'm layering the strategy for later on, right? My client could be surrounded by guards, right, that are right within their reach. I pulled this. This is Adolf Eichmann. He was not one of my clients, thank God. But I was struck by this because, right, he's got these two guards who are right next to him, ready to pounce on him at a moment's notice, right? And also, I thought it looked a lot like the COVID courtrooms we've been trying stuff in for a long time with that plexiglass that way. But you need to be prepared for what it is going to look like, what motions you need to file to make sure that your client, because, they don't put guards right behind the people who come in off the street, right? They don't know that, right? I've had clients that they wanted to put stun devices on, right? Put like a taser attached to their body, right? That means my client, he's going to be always worried there's someone out there with a button, right, that's going to send, 10,000 volts through him. He's not going to appear like he normally would that way, right? And fight those things to make sure that the appearance looks great. All of this, again, is building up in different ways. I may have lost them, but you know what, Judge? Now, if you're not going to prevent me from having prejudicial images of my client out there, right? Well, then, I'm worried about that's happening to the community, so I'm going to have to then, file another motion. Again, I'm doing these later on. I'm going to file a motion to change a venue, right? This was a pro se motion to change venue that happened. You're going to do one that might be a little more formal for it that way. But if I have built up some of what's, this motions before about, Judge, I needed to have this kind of benefit. I needed to not have this prejudicial information. I needed to, have different things happen. Now, when I come to do my change of venue motion, right, I've got some things built up. I'm putting the judge in a tougher spot to do that, right, and layering that. Now, I know that judges don't like to change venue. They're very comfortable in the courtrooms that they're in, right? They like their own little chambers. They know where the coffee machine is, right, and they don't want to change how that works. So I know they're going to be reluctant to do it anyway. If they can change venue, that works for me really well. Just let me disrupt that system. Let me slow it down and make it less efficient, right? But I also expect that most of the time they're not going to be friendly to that, right? That's okay too, because I have my strategy, and most of my primary strategy is to lose that, expect to lose it, because I'm going to go, well, Judge, you're not going to change venue for me, then I'm going to have to spend a lot more time in voir dire talking about what these jurors have heard, what the pretrial publicity has been like, what the prejudice has been like that's existed there. And you know what I need you to do, Judge? Don't rule on that change of venue motion right now, because we need to then have some voir dire about it. And I need you to listen to what their voir dire answers are, and I'm going to need an extensive voir dire on this subject, right? So be prepared for that, Judge. Because the judges will typically, when they're denying this change of venue motion to me, or saying, they don't want to go, Mr. Ramseur, I'm going to give you plenty of time to ask about that. These jurors are going to be great. We're not going to have a problem, and you'll see when you ask them those questions. Great, Judge. I'm going to ask the questions then, right? And when I come, right, to my voir dire, I'm going to have that transcript with me, right? I'm going to hold that judge accountable for the promises that they made as they went along, right? And then when I do have that more extensive questioning, and he wants to deny the motion, I've set up my appellate error, or he didn't let me have that extensive questioning. And now I'm going to argue for appellate error because you didn't let me make my motion sufficiently, right? I wasn't allowed to lay the groundwork I needed, the foundation for my motion, because the judge refused to let me ask that question, right? So that's part of the strategy that we want to work throughout. Now, are there folks here who regularly use questionnaires in your cases? Few people I see. I've used questionnaires in cases, and they can be helpful at times. I will tell you the easiest way to get a judge to agree to give you a questionnaire is to tell the judge it's going to be more efficient, that things are going to go faster, right? Because they want to be efficient. They want to move things through. Now, I may not always believe it when I say it. Okay? Because I don't really want it to move faster that way. But it can be helpful sometimes to have some idea of where a juror's going to go. But as you think through questionnaires, you're going to litigate one, think through how you're going to ask those questions and the form of them. I'm reluctant when I do a questionnaire to ask the most important questions in a way that's going to lock in juror responses that might get them struck, right? I might have something that's more of a range of questions, right? So let's say I want to ask, hey, I wonder if, and you see these questions on, do you think all cops are bastards? Always, never, sometimes, right? And that's great, right? That's good. I do want to know if they want to know that or not, right? And they might have a scale of them, right? Always they're bastards, sometimes they're bastards, never they're bastards, right? Well, I like the scale, right? Because people can place themselves where they want on it. But I may not want to lock in my juror if they say they always think they're bastards, right? Because I might want to keep that juror. That might be okay for me, right? So I'm going to think about how I word that, right? So instead of being always, sometimes, never, I might say often, sometimes, never, right? Because then if they say that often, okay, I know where they're at, but I can now ask them some questions maybe I can flesh that out about how they can certainly be fair in this case that involves some bastard cops, right? So think about how you're doing those questionnaires, because you also don't want to take away the opportunity you're going to have to talk to the jurors during voir dire. You're going to learn great stuff these next 2 days from these folks who are just masters at voir dire and are great at it. And you want to have that opportunity to build that relationship with those jurors. Don't take it away if you're going to have questionnaires, if they're going to take the place of a full and thorough questioning. You need to make that clear when you're making this motion. Now, on the other hand, if you'd like to get all the prosecutor's questions into your questionnaire so that they don't have much to do during it, feel free to let them put that stuff in there, right? Your judge already answered in the questionnaire. I don't know why they should be able to ask this thing again, right? And think through that strategically for what you want to do. Now, again, there's so many different ways this game can go. I don't know what those questions are that are for you in particular, right? You got to think about them. Y'all are smart. You're going to figure that. But if you think about it ahead of time, right? Think about what that's going to look like. Think about what the questions are that you might be basing your peremptory challenges on as well, right? How are you going, what are the factors that you're looking for in your juror and what's there, right? They're going to give you a lot more than I am. But when you're going to find when you start doing this well, when you are having success in voir dire, you're getting jurors struck for cause in particular, that the other side is going to start cheating on you, right? They're going to start having issues with how you do voir dire, and they're going to want to limit you and pull you back from how you're doing it, right? Y'all have prosecution jurisdiction who, right, they come and they have all the criminal records all the time of the jurors, and they've looked in their secret police databases to find out background about all the jurors ahead of time that some paralegal or intern in their office do it that way. I'm going to file a motion to make sure they don't get that advantage for me. There's no reason that a prosecutor should have secret information about a juror that I didn't have. Right? They have access to some database. Great, I need access to that database. Right? I'm going to file a motion so you have to disclose it to me if you use it or not, and if you do, to get it, and watch them try to justify why they should have some information that you don't have. Right? Or they're just going to have to stop using them if they don't want to give that stuff up. Right? The other thing I've been encountering a lot lately is judges who want me, and want both sides, to turn over our voir dire questions before trial. Any of y'all have that in your jurisdictions where the judges require you to turn over voir dire questions? Man, do not agree to that, right? And fight it for what's there. This is them cheating because they know you're better at it, right? And they need to be prepared ahead of time because they're not as skillful as you at voir dire. This is a lawyer skill. This is what we lawyers do. We stand up in front of people and we look them in the eye and we figure out what questions to ask, right? And I may not always know ahead of time. Sometimes I do though, right? But I don't want you to know what they're going to be. Right? And so if I get that kind of motion, I'm going to say, Judge, we're trial lawyers here. I'm going to shame that prosecutor. Right? I'm a trial lawyer. Maybe they need to be, have all this stuff ahead of time and need some cheat sheet, but I don't need it. But my judge is going to say, well, Mr. Ramseur, I want to make sure that I work efficiently here. And I want to make sure that I handle any objections ahead of time. I don't want an improper question posed to these potential jurors. That could be a problem. I'm going to fight it. I'm going to object to it. Right? But my judge may go, nope, I want it. I'm going to require you to give me those voir dire questions ahead of trial so we can go over them. Okay. My next motion is going to be, Judge, this is my motion for the prosecutor to have to give me their opening statement and their direct questions ahead of time. Right? Because you were very clear, Judge, that we need to make sure that nothing objectionable happens ahead of time for these things. And obviously they've prepared those ahead of time. And so I need to make sure. And in fact, the prejudice is even greater after the jury is sworn. Because now it's going to be a mistrial, Judge, if they ask an improper question. Right? So let's just deal with all those objections ahead of time. How about that? I'm going to want their opening statement and their direct, right? And you're going to see that attitude change a little bit, right? There's no reason they should get one and not the other, right? And that's what we need to be pushing back on and fighting this. And I will often do that. I'll tell you to do that when I file my motion objecting. I'm going to go, Judge, if you grant this motion, this is what's coming up next, right? Do not do that. It's going to be a problem for how we do. And then I shame them for not being as prepared for it. Now, the other thing they start to do is they start to cut you back on time, right? You can't have as much time to ask questions. We got to move this thing along. We got to be efficient. I don't think we do, Judge. I don't remember seeing in the Constitution where it said I only got 5 minutes per juror to ask my questions. I have to be able to have that thorough and adequate voir dire. Remember, you told me I was going to get it. I have the transcripts right here. I know you're a woman of your word, right? And you told me I was going to get to ask those questions. I got a bunch more I wanted to ask. And the judge says, well, sorry, I gave you a certain amount of time. And I was like, well, Judge, they answered. I had to listen to them. They took up some of my time. I should get some back, I think, for that. And now, Judge, I'm going to have to proffer into the record all the questions that you wouldn't let me ask. Might even need to proffer from the juror what their answers would have been. And I mean, you might as well just let me ask them at this point in time, right? If we're going to take up all the time for it that way. Judges love it when they get to talk and yuck things up, right? But they hate it when defense lawyers take up the time. But don't let that stop you, right, from doing that. So when I'm also reviewing those transcripts from the judges ahead of time, I'm going to see how are they doing this, right? Are they limiting people? Are they working on time? How much time have they set? When we're setting our trial date, I'm going to set an expectation for the judge. I'm going to need a lot of time in voir dire, judge. Right? It's going to be extensive, what we're going to do. And I don't want you cutting this short because my client's life is on the line here and make sure it works out right. So you may have to file a motion for that. Now, the other thing about chess that I know a little bit is they always let the white pieces go first. Now, I'm not going to do a Chris Rock bit here, okay, about why the white pieces get to always go before the black pieces. But you always know, though, that there's an advantage, right, to going first. If you're playing tennis and you're the server, right, you have an advantage. You get to set the tone of the game. You get to decide how things start, and it's the same way in chess. Well, why does it have to be that way in voir dire, right? Why does the prosecutors always get to go first in voir dire, right? Because if you start doing well in voir dire, right, and you're starting to get people struck, you know what's going to happen is that prosecutor is going to start previewing your questions to those jurors. They're going to start trying to immunize those jurors from what they know you're going to get out of them and lock them in before you ever get there. And that's just cheating, right? And so you can't let them do that. And you got to say, Judge, why can't I go first? Right? This isn't like a trial where the prosecution has the burden of proof, right? Where they have to meet some burden and overcome it. This is jury selection, and there's no burden. And there's no reason, I haven't seen in the Constitution where they get to go first. Show me where it's required that way. But they've been doing it that way for 300 years. So I'm going to file a motion that we should alternate who goes first. Or better yet, Judge, they had the first 300 years, you just give me the next 300 and we'll be even on it, right? Don't let them get away with those kinds of things. These are the kinds of things that we have been accustomed to doing and use, right? Just we're used to it. But think about how you would want it to be perfect, right? And try to make it that way and fight for that, right? And you may not happen the first time, but I'll tell you what's going to happen is now if that prosecutor starts preempting your questions again, right? You go, Judge, I told you they were going to do this. They changed their questions now, and they're shutting this down. Don't let them do it anymore, right? Okay, won't let them do it. Or let me go first. Now, the judges, too, they're active in this a lot of times, right? You think you've got a juror, you've exposed their bias, you found plenty of reasons why they're not going to be there, and your judge is going to pop up and start asking them if they can follow the law. Right? They can follow the instructions as they're given, right? You said earlier you could follow the law, and now you seem to say that you're biased about something, but you weren't lying to me when you told me that thing earlier. I, as the judge, you weren't lying to me and committing a crime and contempt, were you? Right? Because our jurors, when they hear, right, follow the law, right, this is what the law is, they think if they disagree with it, it means they're committing a crime. Okay? That has a huge influence on them. I know you guys, I've questioned a lot of jurors and they get very nervous sometimes. They feel like they're put on the spot when they're being asked questions, right? And so I'll often ask jurors, as I'm sure you guys do, have you ever been, you or anyone close to you, family member, somebody been a victim of a crime? And I'm always amazed by the number of jurors who raise their hand and they go, well, yeah, my uncle was charged with robbery once, right? My son's got a DUI. Well, I didn't ask them if they knew people had been charged with a crime. That's another question. I asked about being victims of crime, but they feel so put on the spot, right? They're so nervous about it that in their mind, they're like, I got to tell all my secrets right now. I got to say something here. And so they really want to get that out there. And the person they most want to please is the judge, right? The judge is their protector. The judge is their shield. And if the judge tells them they should agree to something, they are going to agree with it. They will not disagree. Right? So you have to prevent the judge from doing that and prevent the judge from putting their thumb on their scale. So beforehand, you're going to file a motion saying, Judge, you are not allowed to get active in this jury selection. You are not allowed to follow the law questions. You're not allowed to ask conclusory questions, leading questions of these jurors because it's too much. It's too influential. Right? Now, they're still going to do it. How are they going to justify that? They should be allowed to overbear a juror's will. They should be allowed to do those things. Great, do that because I'm going to have my appellate error again. Thank you very much. And we're going to maybe we're just going to do this trial for practice. The thing about jury selection that we're talking about here a lot, and we all know this, is we don't actually pick our jurors, right? We don't select who our jurors are. And in fact, What we really do is we pick the jurors we don't want, right? And we're left with the ones in between. So while we talk about jury selection, we're really talking about getting rid of the ones that we have there, right? And so you need to think about how we're doing that through challenges, through our strikes, right? And what those strikes mean. So hopefully you've gotten through your questioning already. You found your places that you got your folks for cause out, but now you've got to use these peremptory challenges that are there. And how are you going to use those effectively? Well, I'm going to tell you, I got some problems with peremptory strikes, right? I don't love them. My first problem is I'm never quite sure how it's spelled. Okay? It's really close. And when I was doing this, I kept messing it up, and spell check's terrible. And so, I had to figure that out. So I went and looked up the definition of it and the definition of peremptory. And this is just Merriam-Webster's. And I thought it was interesting. Peremptory, characterized by imperious or arrogant self-assurance. Haughty. I really want to start calling them haughty challenges from now on. I think that'd be great, right? So there's peremptory. Peremptory actually is sort of part of preemptive, I found out. That way, preemptively, right? And this is marked by the seizing of the initiative. Ooh, I like that better, right? That works for me. That's what I'm trying to do here, right? Is I'm trying to seize some initiative. And so I start thinking again about these peremptory strikes and what I'm going to do with them, because I just don't think they really help us as much as they help other sides, right? From the defense side, I just need one. Right? I need one person. And you guys all know the pain of having worked to save a potential juror, right, from that resuscitation that the judge was doing. And you save him from a strike for cause, and then the prosecution, they're just going to strike him, right, with their peremptories that way. And you needed that one person, right, who thought all cops were bastards to be on your jury in this particular case that way, right? We also know the prosecutors are discriminating a bunch about it. Right? I think we need to be having this conversation more about the problems that we're having with peremptory strikes in general, right? If you have a juror who's qualified for cause, what's there? So here's what we're going to do. We're going to do a preemptory strike on peremptories. You see what I did there? And we're going to I'm going to file a motion to the use of peremptory strikes by either side, right? And Judge, we don't need them. We've got jurors who are here they've qualified for cause. Why do I just get to decide some of them I don't like, right? Otherwise qualified citizens. And in that motion, again, I'm going to have this conversation with the judge about how jury selection is going to go. I'm going to talk about the history of peremptory strikes, right? They came over from English common law, right? Hundreds and hundreds of years ago they started, right? Actually after they stopped trial by combat, right? And they started having more juries. They started allowing peremptory strikes, but only for the Crown prosecutors. They're the only ones who got it at first. And then they started letting the defense have a few, or the defense would have some, but the prosecution would have unlimited peremptory strikes to take out whoever they wanted. And eventually, through the common law, it whittled down. And in fact, it's been completely abolished in English common law since 1989, right? They don't have it anymore. So I'm going to talk about that. See, it's this vestige of hundreds of years ago, right, that we don't need anymore. I'm going to have a conversation about how peremptory strikes are racist, right? And they're constantly been used for racist purposes. This is, if you all have seen the case Foster v. Chatham out of the United States Supreme Court, it's one of those fun cases where they actually put a graphic inside the opinion of the court. And this is the graphic, which is the notes from the prosecution team where they were marking who the black people were that they needed to get rid of that way, right? And put in there. Now, this isn't any surprise that they're racist, right? Thurgood Marshall knew this from the beginning too. He said it in Batson in his dissent, right? That look, all we're doing is telling them to lie to us. We're not actually preventing them from being racist if we still allow them to have strikes like this. The only way to prevent that racism is by taking them away. And that's what we've learned through Foster v. Chapman. If you've heard of the Flowers v. Mississippi case, right? Constant retrials because of racism during jury selection that way. Have that conversation. Then, where are my Arizona people here? Arizona? Right? Y'all abolished in 2022, right? Don't have them anymore. How's it working out? Better, right? You don't need them anymore. You qualify somebody. That should be what matters, right? I don't need any more to be saying, well, you know what? I don't like the look of them, right? To strike somebody, we're making that up because there's not really any science to that. So Arizona abolishes in 2022. So they don't need them. Why do we?
The CLE verification code for this program is LOD942. LOD 942.
Now, where are my Washington people at? There we go, a couple Washington people, right? Washington knows it's a problem too, right? They have a rule in Washington that says these reasons are presumptively racist and discriminatory, right? If a prosecutor gives this as a reason for their challenge, right, that the person had prior contact with a law enforcement officer, that they live in a high crime neighborhood, that they've had a child outside of marriage, they're not a native English speaker, presumptively invalid reason for that. So in my motion, I'm going to point these out to the court, right? You should know, Judge, this is what's happening, right, for this, that they've been abused, and now there are some places that say these are presumptively invalid. And now I know I got a lot of California people in here, right? California looked at what Washington did and said, hold my beer, right? We like what you did. We're going to add a couple more on there, right? So they add a couple more too, right? If the prosecutor says the juror was inattentive, or they just had a lack of rapport. What does that mean? Right? You have a lack of rapport with a juror that way. Like prosecutors are so charming, everyone gets along with them. And, right, that these are presumptively invalid. Now I'm laying these out for the judge too, because what I know is my prosecutor might try to use some of those later on in his challenges, right? He's got to think of his own reasons. And if he ever tries to use one of those, Judge, you know those are presumptively invalid. They've been found that way in other jurisdictions. That's racist. He's racist, right? I'm going to have this conversation with the judge about the problem with peremptory challenges and why we shouldn't need them. Because, and I'm going to point out, because really, if we're going to have peremptory challenges, I need to be able to use them in an effective way. And if you don't let me have extensive voir dire, Judge, not just over reasons for cause, not just over bias, not just over prejudice, but other ideas, other thoughts they might have, other inclinations. I need to get to know these jurors better if I'm going to use my peremptory strikes in an intelligent way. If you don't, Judge, I'm going to stereotype. Because I don't have any other choice. You didn't give me another choice but to look at him and go, well, you know what? He's wearing a Patagonia jacket. He must be, wealthy. I don't like him, right? Or they looked at me weird and I just don't think that's right. And I'm going to probably have to go back to some of those reasons we talked about that Washington and California don't really like, right? They live in a high crime neighborhood, right? With their prior contacts. So you can let me have extensive voir dire, Judge, or there's just going to be a problem, right? We're going to use stereotypes. It'll be a problem, right? Have that conversation. Now I know a judge is not likely again to bar any side from using peremptory strikes, but they're going to have to see that I'm right about this stuff, right? We're making good points about it. It may not work this time, but if I get extensive voir dire, we're going to get there with it. Right? And if the other side wants to make some, objection about why I'm striking who I am, I'm going to say, well, I would have found some other reasons, but they wouldn't let me. And fight that, right? So those are part of the battles that we're going to, and you see that's a layered strategy too as we work through about where I'm going to get to eventually there. Now, the other thing we're doing now, we've got through all of this stuff structures. I want to make sure that I'm preserving my record for appeal the right way. Right? You want to make sure that you're filing a motion to get transcripts. And if you can get live transcription when it's happening, it's super helpful, right? Because how many times you've been through voir dire, you're in the zone for it, right? It's always helpful to have someone help them take notes for you, but you'll forget which just juror in the midst of these made that specific answer to that specific question. It's hard to get all the notes taken when you need to. That live transcription or daily transcription, if you have time overnight to do it, is really helpful. File those motions. Explain to the court, I need those to make the basis for what I'm doing. They're going to help us with it. Lie to them and tell them it's going to be more efficient. Maybe they'll believe you. Now, the problem I've also had really in jury selection and on appellate issues, and I'm sure you've all seen this, is the appellate court says, well, the trial judge is in the best position to have judged the demeanor, right, and tone of the witness that was there. Us as appellate judges, we just can't tell off a cold record what the context of that was. I'm like, God, they're right. And I just really wish there was some way that we could invent a machine that could watch the jurors and preserve exactly their demeanor and tone of voice. That'd be really helpful, I think, to help with that problem, right? So I'm going to file a motion to videotape jury selection, right? Now, I know that there are judges who are real protective of the jurors, right? That no one can see their faces, no public should know. That's fine, Judge. You don't have to see their face. No, where I'm going to put it, I'm not going to put it on Amazon Prime or Netflix, right? For what they're doing back there and all the shenanigans that are going on, regardless. But we should have it in the record. Put it in that sealed record, right? Take this video, seal it afterwards, and it'll only be there for appellate purposes if need be or something else happens, right? There's no good reason not to do that, right? We videotape lots of other things. We can do it very unobtrusively that way, right? Tell them that's what we need to do to make this fair. So then, if they grant my motion and I'm on the appellate court, I go, you don't have the excuse anymore, appellate court. You can see their demeanor. You can see the context of it. Decide for yourself. Or they're going to deny that motion, right? And when they deny the motion on appeal, when the court tries to pull that bullshit, be like, I tried to get this for you, and it's error then to not have preserved the evidence like I needed to, for you to do. The judge wouldn't let me then preserve the issue well enough for my appellate thing. And if you judge are going to say you can't decide it because you don't have that information, that's appellate error from the trial judge at that point in time, right? So thinking through again how you're preserving that record and making the most of it as you go along. Now, y'all are going to think a lot of stuff. You're going to see lots of other things throughout this and have other ideas. Really, all I'm trying to do here is spur for you a little bit, because the hope is that you guys are going to end up like this, right? You're going to end up thinking a little more masterfully about your chess games and moving those pieces well ahead of time for what's there, okay? So I know you all can do that if you just think through it, prepare, do those things, and fight the fights to make this a less efficient system at convicting our clients, and y'all will do great. I appreciate you all for your time and attention. If you have any other questions, feel free to come and ask me afterwards. Thank you all.